Dear students, Namaskar. Today again we are going to discuss very important topic, that is the topic of Article 22 of the Constitution, which provides safeguards against arbitrary arrest and detention of the accused. As we have got discussed repeatedly, the bare wordings of Article 21, which provides the guarantee for right to life and personal liberty for the citizens and non-citizens also. Article 21 says that no person shall be deprived his right to life and personal liberty except accordance to the procedure established by law. Here means that although Article 21 gives the guarantee for right to life and personal liberty, but subject to the procedure laid down by the law, means that your right can be taken by the state or your personal liberty can be curtailed if the procedure prescribed by law is going to allow or is going to be permitted. And once we talk about the safeguards against arbitrary arrests and detention extended to the accused of a crime, then we can say, because you know that in case if any person is going to violate the provision of criminal law, then his personal liberty can be curtailed. He could be arrested by the state or by the authority, legal authority. Here, the safeguards means that what's the procedure for making a proper arrest, what's the rights of a arrestee person when he is going to be arrested, he is going to be interrogated, he is going to be produced before the courts. So all those rights has been enumerated under Article 20 of the Constitution. And Article 20 of the Constitution, which talks about the minimum procedure, means that this type of minimum procedure has to be observed, has to be followed by the investigating authority, by the arresting authority, and when any kind of arrest is going to be made, then there is the minimum procedure that has to be followed, that has to be obeyed by the arrest making authorities. Why it is so? It is because of the demand of Article 21 of the Constitution. Because it's the demand of Article 21 of the Constitution that no person shall be deprived his right to life and personal liberty except accordance the procedure prescribed by law. So in case if the law is going to permit, or the procedure prescribed by law is going to permit, then that arrest or that curtailment of right can be declared a lawful curtailment or lawful arrest. But in case if the procedure is not going to permit, then that can be declared illegal or that can be declared unconstitutional. Here, that's why Article 22 prescribe the minimum requirements that must be included in any law enacted by the legislature in accordance with which is the person may be deprived of his life and personal liberty. And this is Article 22, which deals with two separate matters which can be bifurcated into two categories, that the persons detained under ordinary law and the persons detained under preventive detention laws. Article 22, we can say that in case if we talk about the first detention, that is to be made under ordinary law of crimes, laid down procedure has to be followed when a man is arrested, and it is to be clause 1 and 2 of Article 22, which talks about the safeguards once he is going to be arrested under ordinary criminal laws. But clause 3, clause 4, clause 5 and clause 6 of Article 22 talks about the procedural requirements when the person is going to be detained or going to be arrested under preventive detention laws. Now, in case if we talk about Article 22, at one point of time, Article 22 was to be considered not a complete course in regard to the laws providing for preventive detention laws, and the validity of an order of detention should be determined strictly according to the terms within four corners of Article 22. As we can cite Article 22, that when that was not taken as a complete code, as all of you aware, and we discussed and we have got referred one landmark decision or discussed landmark case. That was the case of A.K. Gopalan, which was decided by the Supreme Court in 1950, and all of you know that Mr. Gopalan was detained under detained under preventive detention laws. He was a communist leader. He was detained under preventive detention laws, and he challenged his detention that it's the violation of not only my rights under Article 21, but it's the violation of my fundamental rights under Article 19 of the Constitution. As he argued that right to personal liberty must match with the liberties, must be taken as liberties envisaged under Article 19 of the Constitution, as Article 19 of the Constitution talks of the freedom of movement. So, the freedom of movement is subject to be covered under the ambit of personal liberty of the Constitution. And that's why there is the violation of Article 21, 19, and 14 of the Constitution. But the Supreme Court, as all of you know, we discussed, had taken a very restricted interpretation of Article 19 and 21 and held that there is no relation between Article 19 and 21 of the Constitution, and that's why his detention was upheld because of the reasons that he was uh, uh, he was detained under preventive detention laws. And in case if we talk about the provision of Article 22, the under Article 22 there is a rights of the arrested person who has been detained under preventive detention laws. That is uh, under clause 3, under clause 4, 5, and 6 of the Article 22 of the Constitution. And that reflects little bit exception to all those rights which has been given to the arrested person under ordinary criminal laws. So here Supreme Court interpreted or interpreted the provision of Article 19, 21, and 22 literally, or the law as it is. That's why the Supreme Court had uh, upheld the detention of Mr. A.K. Gopalan. But in R.C. Cooper case, as we have discussed under Article 21, that approach which was adopted or propounded by the Supreme Court was declared wrong. Although this case was related to Article Article 31 clause 2 of the Constitution, but in Menka Gandhi, as you could say that prior to Menka, as we discussed so many times, that there was a literal interpretation was given to Article 21. But after Menka Gandhi, or in Menka, all of you know that the Supreme Court had propounded that the procedure established by law means that the procedure has to be a just, fair, and reasonable, and that has to pass the test of justness, fairness, and reasonableness. And in case if any procedure which is not going to pass the test of reasonableness, justness, or fairness, that procedure cannot be held valid and constitutional procedure. So even if the procedure has been, although the procedure has been prescribed by the law. So after Menka Gandhi, we can say, according to the view, law relating to preventive detention laws must now satisfy not only the requirement of Article 22, but also the requirements of Article 21 of the Constitution. In other words, we can share the procedure prescribed under the preventive detention law must be reasonable, just, and fair under Article 14, 19, and 21 of the Constitution. Now, first we are going to deal with clause 1 and 2 of Article 22, which talks about the rights of the arrested person under ordinary laws. Article 22, clause 1 and 2 guarantee 4 rights on a person who is arrested for any offense under ordinary law. First right that right to be informed, right to be informed as soon as may be, as may be of grounds of arrests. Second right, the right to consult or right to defend and to be represented by a lawyer of his own choice. Third right, the right to be produced before a magistrate within 24 hours. Fourth right, the freedom from detention beyond the said period except by the order of magistrate. So the above fundamental rights guaranteed to arrestee person by clause 1 and 2 of article are available to both citizens as well as non-citizens, and not to the person arrested under or detained under any law providing for preventive detention laws. Because as we go discuss, the rights for the arrested person under preventive detention laws deals under uh, Article 22, Clause 4, 5, and 6 of the Constitution. So the first right, which talks about the right to be informed of grounds of arrest. So it is necessary to enable the arrested person to know the grounds of his arrest, because it will be the violation of principle of natural justice that in case if the grounds of arrest is not going to be detailed to the arrested person, then that arrest may be termed as arbitrary arrest. So that's why it is his constitutional rights to know the grounds of his arrest so that he could prepare himself or prepare his defense, because Article 22 in this nature of directive to the arresting authorities to disclose the grounds of arrest of a person immediately. The words used under Article 22 Clause 1 are as soon as may be, which means in nearly as the reasonable within the reasonable time in the circumstances of particular case, because sometimes the circumstances varies from case to case, but it is the duty of the arresting authority that they must reveal the grounds of arrest as soon as may be. So if the grounds of arrest is delayed, it must be justified by reasonable circumstances. And this right of being informed of the grounds of arrest is not dispensed with by offering him a bail to the arrested person. Means that this right is cannot be dispensed with in case if the police department is going to offer him making a bail, because again it till it is again curtailment of his personal liberty. In case if and why this has been declared by the court, it has been declared in one case. It was the state of MP versus Subbarao. It was decided in 1966, so long back, so that the police department could not make a fake arrest. They must have reasonable grounds for arresting anyone. Means that the police department cannot make a pretense that we have got released him on bail. They must have a genuine and reasonable ground for arresting any person. And for the purpose of uh, making arrests in one landmark case. It was the Jogendra Kumar versus State of UP, which was decided by the Supreme Court in 1994. Here, the Supreme Court laid down guidelines governing arrest of a person during the investigation. So, this is intended to strike a balance between the needs of the police on one hand and the protection of personal liberty or protection of human rights of the citizen from oppression and injustice at the hands of the law enforcing agencies or at the hands of the uh, interrogating agencies or at the hand of the police department. So that's why the court has held that that person is not liable to arrest merely on the suspicion of complicity in an offense. There must be a reasonable justification in the opinion of the police officer affecting the arrest and that such arrest was necessary and justified. Because in case if it is it was not just necessary and justified, then that arrest will be will become encroachment, will become trespass, will become curtailment of personal liberty of the citizens. And that's why it's the not only the courts which has indicated about the unreasonable arrest or detention by the police department, even the National Police Commission in its third report has pointed out that power of arrest is one of the chief source of corruption in the police, and according to that report, nearly 60% arrests are either unnecessary or either unjustified. But it means that 60% arrests were shown as unreasonable, unjust, and unfair arrest by the police department. And that's why the Supreme Court laid down the following guidelines for making justified arrests. That first of all, a person being held in custody is entitled, if he so requests, to have one friend, relative, or other person who is known to him or likely to take an interest in his welfare, told as far as practicable that he has been arrested and where he is being detained. Means that it's the duty of the police department to inform his relative or his friend or another his uh, you can say well wisher who has been revealed by the arrested person, that they must immediately inform the such persons or these persons about his arrest, that he has been arrested by the police department and uh, he has been arrested at that police station or such police station, that must be informed by the police department to his friends or to his relatives. Third, the second, the police officer shall inform the arrested person when he is brought to the police station of this right. And you know that it is always duty of the police department that they must reveal this right of arrested person, that he could inform his relatives or friends through the police department that he has been arrested by the police, that police station, or particularly that police station by the police department. Third, and that an entry must be made in a uh, police diary as to who has informed of its arrest. Means that again it's the paramount duty or constitutional duty of the police department or police officer that they have got informed to the relatives or the particular relatives or friends of the arrested person, and it must be recorded in police diary. And these protections, these protection shall be these protections from power flow from Article 21 and 22, Clause 1 of the Constitution, and must be enforced strictly by the police department. And the court directed the court directed that it shall be the duty of magistrate before whom the arrested person is produced uh, to satisfy himself that these requirement has been obeyed, these requirement has been followed, these requirement has been complied with. So the court said that these guidelines shall be followed in all cases of arrest till legal provision is made by the by on this behalf, means that till the legal provision or till the law is going to enacted by the legislature, these requirements shall be addition to the rights of arrested person and found in the various police manuals. So the police made it clear. So the court made it clarified or clearly pointed out that these requirements are not exhaustive. The DG police of all states in the country shall issue necessary instructions requiring a due observation of the requirements. Means that the court had said that all these directions or requirements are not the exhaustive one, because the another requirements may be enlisted by the courts time to time as per the demand of the circumstances or as per the emerging issues and challenge of the society. In case if the fake arrests are going to be made by the law enforcing agencies. So the judgment of the Supreme Court will protect innocent citizens from being arrested and harassed by the police merely on the suspicion of complicity in an offense. The second right, as we discussed, that be right to defend by a lawyer of his choice. In America, if a person is arrested, he must be afforded opportunity to consult a lawyer of his own choice. And if he is unable to employ a counsel, it is the duty of courts to provide him a lawyer for the protection of his right. Although that again we can say got here the landmark decision of our apex court, that is the decision of Menka Gandhi, that prior to Menka Gandhi in our country, in India, in view of this, that decision, that there was not the government was not bound to provide the help of the lawyer unless request was made by the arresting person. But as a result, in the ruling of Supreme Court in Menka Gandhi case, because the procedure has to be just, fair, and reasonable. So you know that we discussed under Article 21 that there were a lot of series of decisions which were decided, uh, lot of decisions related to Article 21 which were decided in the light of the uh, guidelines or in the light of the decision of Menka Gandhi. And you know, we discussed in that under Article 21 that the decisions of the decision of Menka Gandhi had widened the horizons of Article 21 of the Constitution. And it had post Menka, the Supreme Court or the courts has conferred a lot of implied fundamental rights, including right to livelihood, including right to clean environment, even right against handcuffing, etc. Means, and all those were related to Article 21 of the Constitution, and all those related to Article uh, 22 of the Constitution, also which talks about the article, uh, which talks about the safeguards to the arresting person. And here, that after Menka Gandhi, in a series of cases following that case, that it is clear that the courts will bound to provide the assistance of a lawyer to a person arrested under a ordinary law also. Ordinary law also. And all of you know that in one case, which we had discussed earlier also under Article 21 of the Constitution, Husnera Khatun versus Home Secretary of State of Bihar. And all of you know that this case was only decided by the Supreme Court in 1979. And all of you know it very well that the case of Menka Gandhi was decided in 1978. So the opinion or the approach uh, of Menka Gandhi was followed by the Supreme Court in Husainera Khatun versus State of Bihar. The Supreme Court has held that it is the constitutional right of every accused person who is unable to engage a lawyer and secure a legal services on account of reason such as poverty or such in indigence, indigence or extreme poverty, means poverty or extreme poverty, or incommunicado situations, means that all in those situations when he is not allowed to communicate with others, incommunicado situations, to have free legal services provided to him by the state, and the state is under constitutional duty to provide a lawyer to such person if the records or if the needs of justice is so required, because ultimate, as you know, that it's the duty of the courts, it's the duty of the law to dispense justice, to dispense justice to the society. So if free legal service is not provided, the trial itself may be vitiated as contravening to Article 21 of the Constitution. Means that in case if the free legal aid is not going to be provided, then it will destroy. It will destroy to what? It will destroy to the legal validity or legal right which has been uh, guaranteed under Article 21 of the Constitution. Means that then there will the right under Article 21 will be become meaningless, purposeless, in case the free legal aid is not going to be provided by the state. In One case, that which is the very uh, landmark decision, which is the facts of that case, all of you know, very interesting, and that is the case of Muhammad Azlam, Muhammad Ajmal Kasab, and popularly that case is known as a uh, Kasab case, and versus state of Maharashtra. In that case, it was the Supreme Court has held that it is the constitutional rights of every accused person who is unable to engage a lawyer and secure a legal services on account of reasons such as on account of reasons. So in that case, what happens? That on account of reasons of poverty, etc. But in this case, as all of you know, that this Bombay terror attack case, it is popularly known as Bombay terror attack case, the case of Kasab. The accused was a Pakistani nation, uh, was offered lawyer at the time of his arrest, but he denied. Thereafter, he assertively denied the services of Indian lawyer and made the request for the lawyer of his home country. When he was convinced that no aid would be given by his home country, the demand for lawyer was made by him, and which was immediately provided to him. And the accused could not to be said that it has not that the safeguard has been have been denied to the whole national, or that the safeguard has been denied, and any of his fundamental rights has been violated. The right available to the accused at the first stage of protection before the magistrate. So, right to be represented by a lawyer and the right against self-incrimination would not remain incomplete and unsatisfied if these rights are not read out to the accused. Means that it is the duty of the department, or it is the duty of the courts, or the police department to inform him that he could engage a lawyer uh, of his own choice. And any failure to provide legal aid to the accused at the beginning or before his confession to record it under section 164 would not render the trial illegal. Why? Because that again the there is a conflicting interest of two sides. On one hand, it is the conflict interest of the criminal justice. On other hand, it is the interest of the personal liberty. So that's why sometimes that under as and when the statement is going to be recorded under 164 of CRPC, and in case if the lawyer's assistance is not going to provide it during the interrogation or 164, then it would not render to the trial illegal. The objective of the criminal law is to find out the truth, not to shield the accused from the consequences of his wrong. That's the point. And it would be incorrect and unreasonable restricted construction of the constitutional and statutory provision if it is said that 22 clause 1 merely allows an arrested person to consult a legal practitioner of his choice, and the right to be defended by the legal practitioner crystallizes at the stage of commencement of the trial in terms of section 304 of CRPC. He needs the lawyer at the stage of his first production before the magistrate. So it is duty, not obligation, sorry, it is duty and obligation of the magistrate before whom the person accused is going to be produced under cognizable offences. First time is going to be produced to make him fully aware of his right to consult and be defended by a legal practitioner of his choice. And in case if he has no means to engage the lawyer of his choice, then one would be provided him, that it's the duty of the state to provide him legal aid or legal assistance at the cost of or at the expense of state. So this right does not mean something or does not mean sanctioning or permitting the presence of lawyer during police interrogation. And it has been laid down by the Supreme Court again. This landmark judgment or landmark case, it was the decision in the Kasab case. The sometimes what happened that the bar association, is going to take their own decisions in particular state, and uh, it's the bar association a particular state which is uh, going to pass one resolution that not to defend some persons in criminal cases. Means that it was the bar association, and it was to be happened in one case. It was the case of A.S. Muhammad Rafi versus state of Tamil Nadu, and it was the case of 2011. Here, what was the problem and what were the facts? The Bar Association of Coimbatore in Tamil Nadu state had passed a resolution that no member of Coimbatore bar would defend the accused policeman in a case. Means that in case if the policeman is accused, then the bar association of Coimbatore will not tender him any kind of legal assistance. And the case was, as when it was brought to the notice of Supreme Court, then the Supreme Court by the bench of two judges, Justice Markandev Katju and Justice Gyan Sudha Mishra. Here, the resolution served by the Bar Association all over the India that they would not defend a particular person or persons in a particular criminal case are wholly illegal and against the traditions of bar and against the professional ethics also, because they have got because lawyer is means to tender the services to the community. And every person, however, the court had held that however the every person uh, may be, however, wicked, depraved, wild, or perverted, loathsome, or vicious, or repulsive, he may be regarded by the society that he is going to be considered repulsive, vicious, loathsome, or wicked, depraved, etc. But uh, but He has a right to defend in a court of law, and correspondingly, it is the duty of the lawyer to defend him. Professional ethics require that lawyer cannot refuse a brief action, or cannot refused a brief provided a client is willing to pay his fee and the lawyer is not otherwise engaged. So the action of any bar association in passing such a resolution that none of its member will appear for a particular accused, either on the ground that he is a policeman or suspected terrorist or rapist or mass murder, etc. So it's against all norms of the constitution, and against the statutes, against the professional ethics. So such a resolution is a disgrace to the legal community also. So all uh, such resolutions are null and void, and the right minded lawyers should ignore and defy such resolutions. So, if they want democracy and the rule of law uh, to be upheld in this country, it is the duty of the lawyer to defend, uh, to defend no matter what the consequences. And the lawyer who refuses to do so, refused to do, is not following the message of Gita or message of Bible or message of you know Holy Quran or message of any message of even God. So the court directed the registry to circulate copies of these judgments to the high courts, bar association, and state bar councils, and the court also requested the high court, bar association to circulate judgments to all the district courts, district bar association in their states and union territories. The third right, that right to be produced before a magistrate. Uh, in addition to the furnishing, that we can say, the first of all, if the grounds must be detailed to the arrested person, or we can say he should be produced before the magistrate within 24 hours. He should be, uh, you know, he should be uh, having the right to defend himself and to engage a lawyer of his own choice. Now, third, uh, you know, important right, that he is having right to produce before a magistrate within 24 hours. So it can be extended beyond 24 hours only under the judicial custody. Means that beyond 24 hours, in case if it is going to be extended by the magistrate, then he should be taken to the judicial custody, not to the police custody. So it affords a possibility, if not an opportunity, for immediate release in case the arrest is not justified. Means that in case if magistrate finds it that he was not arrested justifiably, then his release must be made forthwith. Then fourth, uh, important right that no detention beyond 24 hours except by the order of magistrate. So this means that if there is a necessity of detention beyond 24 hours, it is only possible under judicial custody. So the expression arrest and detention in Article 22 Clause 1 and 20 Clause 2 was held not to apply to a person arrested under warrant issued by the court on a criminal law, on a criminal or the quasi criminal complaint, or under security uh, proceedings. Security proceedings means that in case of detention is going to be made because of the security reasons, then 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 this extension can be made beyond 24 hours. So Article 21 is designed to give protection against the act of the executive or orders of non-judicial authorities, and applies to a person who has been accused of crimes or of an offense of criminal or quasi criminal nature, or some act prejudicial judicial to the state or in public interest. Uh, Thus, under Article 22, Clause 1 and 2, the arrested person has a right to be produced before the magistrate within the 24 hours. Period of 24 hours, and this would enable the arrested person to get a speedy trial. Why this provision has been made? Because that will help out a arrested person for speedy trial. And this means that if there is a failure to produce the arrested person before the nearest magistrate within 24 hours, it would make the arrest illegal arrest or unlawful arrest. So this is also available to a person arrested under a warrant issued by the Speaker of Legislative Assembly. Means that in case if the Speaker is going to be exercise his privileges, then against any person, then that uh, safeguards under Article 22 is available and is to be given to that arrested person who has been detained and who has been detained because of the order of the Speaker, because of the parliamentary privilege or legislative legislature privilege. And in one case, otherwise it will be the violation of 22 Clause 2. In one case, it was the case of State of Punjab versus Ajaib Singh. It's very old case that the Supreme Court held valid that Abducted Person Recovery and Restoration Act 1949, under which a abducted person could be arrested and delivered to the officer in charge to the nearest camp. So the arrest of an abducted person under the act was held not to be constitute a arrest or detained, because the person was not accused of any offense of the criminal or quasi criminal nature. So likewise, the removal of a minor girl from the brothel house or brothel under the Bengal Suppression of Immoral Traffic Act 1923 was held not to be constitute arrest and detention under Article 22. So the reason is that person who is arrested under warrant of court is uninformed the grounds of his arrest. Now, uh, we are having one welcoming ruling, which has been laid down by the Supreme Court. In one case, it was the case of CBI versus Anupam J. Kulkarni. Here, the Supreme Court laid down a detailed guidelines governing arrest of an accused when investigation cannot be completed within 24 hours. The court has held that when a person is arrested under Section 57 of CRPC, he should be produced before the magistrate within 24 hours or nearest magistrate within 24 hours. The judicial magistrate can authorize the detention of the accused in such custody, either police or judicial, from time to time, but the total period of detention cannot exceed 15 days in the whole. After the expiry of first period, means that in the first phase, after the expiry of 15 days, the further remand can only be given in judicial custody, not in police custody. So, if the investigation is not completed within 19 days, or there cannot be any detention in the police custody after the expiry of first 15 days. And but if the investigation is not going to be completed within the 19 days or 60 days, when the accused has to be released on bail as provided under Section 167 of CRPC. Now, this period of 90 days or 60 days has to be computed from the date of detention as per the orders of magistrate, not from the date of arrest by the police department. So, thus, after the expiry of the 15 days, it should only be under judicial custody. So, we can say that it was one kind of welcome ruling of Supreme Court. This would save many under trial prisoners from police atrocities, as they cannot be kept for a long period or undue long period in police lockup, and would also help in speedy investigation of crimes. Now, uh, what is the exception? Exception to Article 22, Clause 1 and Clause 2. The It's Article 22, or you could say the Clause 3 of Article 22 provides two exceptions to the rule contained under 22 Clause 1 and 2. It says that the rights given to the arrested person under Clause 1 and 2 are not available to the following person. First, as we discussed, first it is uh, enemy, alien maybe, however, seek the protection. Uh, they seek the protection under Clause 4, 5, and you know that if the arrest is made under the preventive detention laws, but subject to the law passed by the parliament, means that they could seek the rights. They could means that the arrested person uh, who has been arrested under preventive detention laws, they could seek the rights, their rights, from Clause 4 to 7 of Article 22 of the Constitution. So, and which has to be followed if a person is arrested under the preventive detention law. There is no authoritative definition of preventive detention law, and you know that we are having, although in few countries there is no provision for preventive detention laws, even in US, there is no provision, there is no such law, and it was resorted, but in our country, it was resorted to in England only during the wartime, and in England first time during the First World War, and certain regulations were framed for uh, preventive detentions under the Defence Realm Act provided by the preventive detention at the satisfaction of the Home Secretary as far measures at the ceased to have effect at the conclusion of hostilities. So the same being happening during the Second World War, and you know that it is our uh, constitution under Indian constitution, however, recognize the preventive detentions in normal times also, and you know that as we discussed, although we discussed A.K. Gopal case in which the preventive detention laws was to be upheld and was to be declared in the light of Article 19, no, sorry, 21 of the Constitution. And we also discussed, that one A.K. Roy case versus Union of India, and that was discussed under the ordinance making power, and that National Security Act or ordinance, that which was made by the National Security Ordinance was enacted by the government, and it was declared, declared constitutional because the executive was empowered to promulgate ordinance, so the joint ordinance making power under Article 123 of the Constitution. And there are other, another preventive measures acts which has been uh, made by the Parliament time to time. Of that it was like that TADA, Terrorist and Disruptive Activities Prevention Act of 1987, later on which was repealed as and when it was found that there was the misuse on the name of TADA. So uh, it's we can say the court and even preventive detention laws which were we have got discussed that ADM Jabalpur case, which is popularly known as habeas corpus case, and in that case, all of you know that even writ provision was not upheld. Writ provision was not available to the arrested person for preventive detention laws. And, although the habeas corpus case that was related to Article 359 of the Constitution, or the order issued by the President by 359, and the Supreme Court upheld the constitutionality and validity. Although that ruling was very severely and badly criticized from the all corner of the society, but later on, that ruling was declared or for the purpose of nullifying the consequences of that ruling uh, in 1978. It was the Janata Party government which amended the constitution by 44th constitutional amendment, and that now the rights of the person, rights of the citizen cannot be curtailed, cannot be violated, even during emergency under, under Article uh, 21, 20 and 21 of the Constitution, means that both those can be restored, can be protected. The courts could issue the dates as it was denied in your habeas corpus case, ATM Jabalpur case. So it's all regarding Article 22 of the Constitution. which talks about the rights to the arrested person either. It's and in case if we talk about the little bit more about your although we have got discussed a little bit portion of article 22 clause 5 to 7, but however we can discuss that it's the second part. First part was related to clause 1 and 2, and now and 3 is the exception to 1 and 2, and now the second part, which comprises of clause 4 and 5, provide that safeguard to the detainees or arrested person under the law for preventive detention, and it is noteworthy that these safeguards are available even to the, as I got discussed, even to the enemy aliens. Preventive detention is the detention of a person where the evidence against him is not sufficient for his conviction by a court, but is sufficient to justify his detention for reasons of defense, reasons of foreign affairs, security of state, or uh, maintenance of public order, etc. So all this punitive detention punishes a person for something done by. So punitive detention prevents a person from doing something preventive in nature, or preventive detention is a precaution, we can say. It is one kind of precaution taken by the executive, by the government. Its justification is reasonable, suspicious, so, and maybe probability. So it would be instructive to note the observation of judge of the Supreme Court regarding the preventive detention, although you know that and very what was the instructive to note the observation made by the Supreme Court, observation of judges of the Supreme Court, again in Gopalan case, A.K. Gopalan case, and it was Justice Mahajan. Justice Mahajan, uh, Justice Mahajan observed that preventive detention laws are repugnant to democratic constitutions. Repugnant to democratic constitutions, because and it is obvious, that that's why the few that's why the few countries like US has not opted for the provision for preventive detention, and he quoted that preventive detention is unknown in America. It was resorted to It was resorted in England only during the wartime, but no country in the world that I am aware of has made this an integral part of their constitution, as has been done in our India. So this is unfortunately, or this is undoubtedly unfortunate. So it has been quoted by the Justice Mahajan, and our constitution has so far, or our government so far, considered that preventive detention is necessary, but it must be subject to limitation to prevent misuse. Examples we can provide: the first Preventive Detention Act was uh, introduced in 1950, under which that Gopalan was arrested. Now it has been repealed. And another, it was the MISA, Maintenance of Internal Security Act 1971. It is because of the war, and now it also has been repealed. Then another is the COPIPOSA, uh, Conservation of Foreign Exchange and Prevention of Smuggling Activities Act of 1974. Then next is the National Security Act 1980 and Prevention of Terrorism Ordinance 2001. So all such acts must be conformed and contain the safeguards provided in Article 22. And here, what are the safeguards to the arrestee of preventive detention law? That if the uh, detention is for more than 3 months, then the matter must be referred to an advisory board, and the detention may be continued only where the advisory board considers that all are sufficient uh, grounds for the detention. Grounds of detention must be communicated to the detainee. The arrestee or detainee must be given an opportunity to make a representation against the order of detention. And you know that it's all regarding Article 22 of the Constitution. And now I'm going to little bit discuss Article uh, 23. In case uh, we talk about article, it is again very very important article, Article uh, 23 and 24. Article 23 uh, okay, we'll continue in our next lecture, because sometimes you know that what I had past experience, that now the lecture has been more than now so far lecture I delivered. It has been more than 1 hour, and sometimes in case if it is recorded more than 1 hour, then it is not going to be recorded completely. So sometimes you know that it creates problem. So I have now stopped my voice. Again, I request all of you that in case if you have any kind of doubt or inquiry or any kind of question, then kindly again you could arrange for Zoom meeting by asking to Mr. Baum or Mr. Abhishek Agarwal from G section. Thanks a lot. Thank you.